Started on debating the bill, which is I want to express my dissatisfaction publicly about today's agenda containing 52 items and the lack of time that was granted to the minority party to review this language. I do appreciate the chairs giving us a couple of additional hours today to take a look at this. But as you can see from looking at my desk, this is a lot of information to get through, and I just think it's a disservice to the people of Connecticut when we are not afforded enough time to go through these bills. I would say this very first bill that's on this agenda would warrant an entire legislative session itself worth of debate. And we are going to clearly limit that substantially if we are going to get through even a portion of this agenda today. And in my view, that is a direct result of what I would only describe as arrogance from the majority party. And I want to just couch that in the terms that I have great respect for my colleagues. And I just think that what's happened is over time, this majority has become so accustomed to business as usual and so comfortable in the way they operate with utter disregard for whether the minority has the chance to review information or they have the opportunity to have their voices heard or have their amendments properly considered, et cetera. That's just a matter of course for them. I get along very well with the chairs, and I don't want to harm that relationship, but I will say that it is symptomatic of this entire Connecticut state government, and particularly this legislature, that very, very rarely is there a real debate on the substance of these bills to the degree that I think people back home would expect and is certainly warranted. I'll get right into this first bill. I appreciate the chairman's comments about protecting the environment. I think everyone in the sound of my voice, certainly my colleagues around this room in both parties, all care about the environment. If you hear anything to the contrary, don't believe that. That's a bunch of nonsense. It's made for political division and to create factions that hate each other, frankly, for the benefit of politicians. What I come here to do every day is to debate policy for the benefit of the people of Connecticut. And sometimes the policy that's put in front of me is good, and sometimes it's not. It doesn't mean I don't care about certain people or certain issues. I certainly care about the environment. I grew up actually spending all my time outside and becoming super interested in the sciences, joined the Audubon Society, the National Wildlife Federation, spent many hours and days doing things outside, hiking, fishing, all of those things. The environment is unbelievably important to me, and it needs to be preserved for future generations to exist. There's no question about that. The question is about the bill that is in front of us, which is a wish list for certain advocates. And when the bill occurs and you see that when the vote occurs on the bill and you see that there are a number of people yes and there's a number of people no, you've got to realize that there's a reason for that. And it's not about who likes the environment and who doesn't. It's about who thinks this is the proper way to get where we're going or has concerns about the language in the bill for other reasons. So I'm going to try and explain my concerns about this. The first thing is that this is a constitutional amendment. It's not just a bill. This is a constitutional amendment. This is a big, big deal to go ahead and make changes to our state constitution, just like making changes to the U.S. Constitution is a big deal. And we have a process for that. The process starts with a committee vote and ultimately a legislative vote. And then a third piece of that is the vote of the people of Connecticut. So there are a few steps and checks along the way, which is a good thing. There's actually a requirement in the legislature that a constitutional amendment has got to pass by a certain majority. I can't remember, is it 2/3 or 3/4, something like that, in one legislative session for it to advance to the people. And if that does not occur, then it has to be passed in two separate legislatures by a simple majority vote. Either way, I think that this is a controversial bill. It's been on our agenda in the past. We've debated it in previous years. And every year I'm handed the same bill, or at least substantially. I don't know if it's the exact same word for word, but nothing of any substance has changed, because the majority seems to like the language as it is and has not taken any of my suggestions. But this constitutional amendment would create something that sounds really good to the casual observer, which is to create a green amendment, to create an amendment that says that every citizen is guaranteed a right to clean and healthy air, water, soil, and ecosystems, and also a safe and stable climate. It goes on to say that the state must protect these rights equitably for all people. It says that the state must conserve, manage, protect, and maintain natural resources for present and future generations. And then it says the state may not allow for degradation of the environment if it is avoidable or leads to significant environmental harm. And it finally states that these rights are equivalent to all other inalienable constitutional rights, like the freedom of speech, the right to bear arms, and so forth, and may be directly invoked and enforced by the residents. That final part's important because it means that that right is self-executing and it's enforceable in a courtroom. All of that sounds very good to a layman until you realize what is being constructed here, which is a transfer of our current system of representation, where the citizens of Connecticut elect their representatives, their state senators, and their House representatives to a state legislature, and of course to Congress as well. And those people are entrusted to make policy for the state of Connecticut. And that's what we're all sitting here for, as representatives of our constituents back home, to make good decisions about what the policies of the state will be. And those are all policies that have to do with the things we mentioned: environmental policy, energy policy. Those things are debated. We have an energy committee. We have an environment committee. And the reason why we have those committees is so that the representatives of the people can come here and debate and vote on those policies and determine what the best outcomes are. And some of the conversations have to do with whether or not we're going to place a power plant someplace, or we're going to allow people to burn certain things, or the placement of some type of infrastructure and its impact on the environment. All those things are debated by the people's representatives. So every citizen in Connecticut has a voice in those decisions. Everybody gets a chance to say something. And anybody who wants me to do something or vote a certain way can contact me and say, "Hey, Rob, I want you to do this. This is this thing. I don't like this. Don't do that. Vote against it." Or, "No, this is a great idea." You all have that voice currently. The danger with this legislation before us is this takes away your voice. It replaces it in a way that gives you maybe a louder voice, but only a singular voice that will be replaced by a mechanism that takes away the ability of all of the representatives' collective representation of the people of Connecticut and puts it in the hands of a courtroom. And potentially one judge will ultimately be the decider on these policies. So instead of all of us coming up here and hearing from the various interested parties and talking to the neighbors or the people impacted on these policies about where the dump is going to go, for example, and making good decisions, representing the people back home and working together in concert, hearing all the voices and all the stakeholders and listening to the various advocacy organizations on all sides of these issues and making decisions like that, all that goes away in exchange for somebody making a claim, a bunch of lawyers making a lot of money, and a judge deciding for all of us. That's what this bill does in essence. We've debated this bill every year, and repeated to me is the same falsehood every time, which is that individuals cannot sue one another under this bill. The proponents contend that this bill only allows individuals to sue the government for redress on these environmental concerns. But that's not true. The bill itself says the claims may be directly invoked and enforced by the residents of the state. So that means any resident has the ability to bring a lawsuit. And the lawsuit can assert a violation of the constitutional right that is established. And I already described the language of the bill, equitably for all people. If I'm already stumbling over my words, it's going to be a long day. Let me just say. It also says that the courts have to treat this right equivalently to all other rights. And of course, we know that people bring claims against one another for other constitutional rights. People will argue over the Second Amendment because a business disallows someone from carrying a firearm in the business. Or there are arguments over speech and who should bake a cake for a gay couple getting married, etc. Those are all claims that are brought from one citizen against another citizen or a business or industry that are constitutionally protected rights. My concern about this bill is that not only are we replacing the representative system that incorporates everyone's voice in the decision-making process and really hears from all of the stakeholders, because anyone can come to the legislature or any one of us anytime if they're for or against any bit of legislation and tell us why. I don't think a judge is going to have that same ability to collect that level of information. And I also don't think that they're going to operate in the same way. The courtroom is going to limit the parties to making the arguments that are acceptable based on the court case that's involved. And that judge is going to have their own internal bias on how they view this Green Amendment and the circumstances before the court. Anyway, that's my argument for why this bill does create constitutionally protected standing for individuals who are bringing these lawsuits. So private lawsuits will occur because of direct constitutional claims, civil actions that invoke constitutional rights. More examples: neighborhood pollution. Somebody doesn't like someone has a bonfire in their backyard. Construction activity, noise pollution, development in a neighborhood, things like that. What that means basically is that even if the government approved a certain amount of activity to place a dump somewhere, for example, that doesn't preclude the parties that are directly involved from being sued by individuals or to sue one another. And this effectively is going to make, as I keep mentioning, the court to be the final arbiter. So this brings us to the other concern I have about the bill, which is that not only are we shifting that, what I think is a significant way of determining policy and upending the system we have, that we elect people to go make these decisions for us as a representative republic, and instead we're going to replace that with a courtroom. But that means we're replacing representatives with a bunch of attorneys who have their own self-interests and the interest of their clients at stake, and not the sense of good policy and the accountability of the people that they represent as we do. But what makes it worse is the language in the bill. And I almost suspect that this bill is being driven by a few different factions. I think you have some very, very concerned environmentalists that are pushing this bill because they're very concerned about the future of our planet and making sure that we maintain the Earth as a place that is conducive for human beings for a long, long time into the future, as well as the flora and fauna that exists. And so am I. But I also think that there's another entity that's involved in this, and I have to just assume it's the trial lawyers that are going to stand to make a lot of money off of policy that is passed like this, because the language in here is basically a litigator's dream, in my view, because it's so unbelievably vague and subjective. Clean and healthy environment is not a statistical certainty. Someone's definition of a clean and healthy environment is completely and utterly subjective. You know, people that live in the slums of India probably do not think that to have the same definition of a clean environment. They'd probably be happy to have even a moderate increase in the quality of life that they have there. And again, I didn't mean to pick and choose anything. I just use an example, a place where there's a lot of poverty and poor conditions because they don't have the proper sewage or water treatment infrastructure like we have in America. The fact is that, it's a relative and subjective term. I'll just leave it there. Safe and stable climate. And what does that even mean? I mean, our climate changes by the minute. It may rain this afternoon. That's what I'm hearing. Stable climate, does that mean, over a period of time, the temperature fluctuations or something that is measurable? None of that's in the bill. So how much is too much? What's unstable? Avoidable degradation. This is a real key component of this bill. This bill requires the state and the courts, rather, to act if they believe that there's degradation that is avoidable. Again, completely subjective. That's going to be a courtroom deciding what they consider to be avoidable, whether or not a certain amount of pollution runoff or smoke or something can be changed, the output of a manufacturing facility, etc. I'd also just kind of point out that our air quality in Connecticut is really not up to us. We tend to get the air that came from the west of us, and we've had legislation in this building in recent years about automobile pollution and so forth. At the end of the day, when there are entire nations that outnumber us in souls by the significant, what's the term for the, anyway, I can't figure out the word right now. It's starting to be one of those days already. Exponent. That's the word I was looking for. I had to go back to 7th grade math to go find exponents. But there you go. I mean, China is out there. They don't give one darn care at all about the environment. They're doing things we would never dream of. And of course, over here, we're doing crazy things like buying electric cars that are reliant on batteries that are destroying the environment in the way that they're mined in China. So people that are very environmentally minded are also making decisions that are not making sense from an environmental standpoint. And it's very difficult to wrap your head around all of it because not everybody understands all of the different ways things occur in this world. But I can tell you that the people that drafted this bill knew what they were doing. They knew they were drafting a bill that contains things like significant environmental harm. What's significant? How much pollution is too much pollution? It doesn't say 4 parts per million in this bill. It says significant. So that'll be litigated. Court will decide what's significant. And you know what happens when the court decides? The court will set a precedent. And that precedent will be relied on by other courts or ignored by other courts until you end up have a patchwork of different decisions where people can't agree on all of these things. That is why we have a legislature. That is why we live in America where we have representative government, so we can choose people who represent the collective voice of the people to come and make these decisions. And we're ultimately accountable back to those people, too, that we actually have to get elected by doing a good job. If we do things that damage the environment, guess what? People back home are like, what are you doing? We're going to throw you out, put somebody else in to protect the environment. And these elections occur regularly for different levels of government, and they are very effective. And you can look back through history and find examples of people that have been elected to public office who have lost elections because they made bad decisions about the environment. So judges will ultimately decide what is clean, what is healthy, what is avoidable, what is significant. Safe and stable climate. I'll just come back to that for a second. Think about all the things that might be affected by this notion of a safe and stable climate. Energy policy, building development, transportation infrastructure, agricultural, industrial activity, housing construction. All of that is going to be contingent on the court's determination of what a safe and stable environment is. I bet you if we went around this room and we started asking people one-on-one privately to describe that, we're going to get a different answer from every single person. In fact, we have people who differ wildly on basic questions about climate change, for example. Is climate change real? How much climate change is attributed to man's impact on the world? I mean, these are things that people are debating over. There's no settled science as much as anyone would like you to believe there is. There are difference of opinions. As many scientists as we could get on the subject, we're going to have that same number of opinions. And instead of having a representative government that allows lawmakers to weigh this information and use their collective ability as a group who represents a multitude of people with different views to come to conclusions that benefit everyone, we're going to put this in the hands of one person. And that could be the one person that has the entirely opposite view than you do. Not only that, even if the situation doesn't come to fruition where the judge in the court finds for or against some particular claim in a way that you agree or disagree with, this can also be used as a delaying tactic. This can be used as a mechanism to stop the placement of some sort of infrastructure or a natural gas pipeline or God knows what. Because now you have created a mechanism where individual citizens can start suing the government and suing each other over and over about every last little potential violation of what someone's interpretation of clean and healthy is, or what is stable, or what's the significant environmental harm. That is a very low burden. In fact, it's so subjective that I would say that you could file a claim about anything. You could claim that your neighbor is polluting your air because they have a bonfire in their backyard. That could be a legitimate claim. And then a court could actually decide that they're right and prohibit people from being able to have a backyard fire pit. That's a real possibility from a bill like this. The proponents of this legislation like to talk about how this has been enacted in other states in recent years and nothing big has happened. But that's not exactly accurate or true. First off, the bill in this instance is not necessarily the same bill that passed in those other states. I hear people say this all the time. Well, they passed the same bill in California. I'm like, is it the same bill or is it the same subject? I don't know what the bills in the other states say. I don't know if they put parts per million in their determination of what we have as subjective in our bill. But I can tell you that there is a very great magnitude of lawsuits that are pending in places like Pennsylvania and Montana, where these policies have been implemented or resurrected in recent years. In 2021, New York adopted it, and litigation began almost immediately. People suing over landfill permits, water contamination, industrial operations. So there are lawsuits happening, pending, being decided, that are creating a patchwork of policy. If this legislation becomes the law in the state of Connecticut, it's going to affect permitting decisions here. Every environmental permit becomes vulnerable effectively to a constitutional challenge. Every infrastructure project is now subject to a potential constitutional challenge. Even local zoning boards, if they try and make a decision about where to place or to approve some sort of development, State policy we've already talked about. So there's a lot more to talk about here. And as I started, there's 52 items on our agenda, which I reminded the chairs, by the way, that even if we spent 5 minutes on every bill, is nearly 5 hours, not including the time it takes to vote. And I've spent about 20 minutes talking on this one bill, and I will tell you it's nowhere near enough. This is a policy that will have far-reaching and long-lasting impacts. It should not be done arbitrarily at the last minute with very little notice and among a stack of other incredibly important policy decisions that this legislature is being asked to face. Before I go, I just want to say a couple other quick points that I didn't get into, but are worthy of further conversation and debate. And if this bill does make it to the Senate floor at some point, because it is a Senate resolution, I'll certainly expand more on these things, but there's the future generations clause in this bill, which is a whole other thing. You talk about subjective. This whole idea that now not only are we talking about what's happening in the here and now, but we also have got to factor in the court's ability to predict what may happen as a result of any particular claim. And obviously affecting people that aren't even born yet. There's also the fund diversion clause. The amendment prohibits diversion of funds supporting protection of the state's natural resources. So this would basically say that if there's money that the state uses for some protection of natural resources, they can't use it for some other purpose. And that's very simplistic and childlike way of looking at the world, I think. I mean, who cares as long as the result is the same or better? We find new ways to do things all the time. But to say that you cannot change anything, to me, is short-sighted, and it does not open the door for new solutions. So, to summarize, this bill's a lawyer's dream. It's written in completely subjective language, and even if it was perfect, even if it set very, very objective parameters that we agreed to, it still replaces the representation principle of our American system of government with a judge's decision after listening to lawyers probably who are not necessarily going to be matched in their ability or compensation argue a case before them. And we will all live with the decisions that they make. For those reasons, Madam Chairman, Mr. Chairman, I will be a no today. Thank you.
Thank you, Senator. Further question or comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote. Okay. This is a roll call vote on SJ 37, a resolution proposing an amendment to the state constitution concerning environmental rights. The motion is to JF to the floor. Senator Flexner. Rep. Blumenthal.
Yes.
Senator Honig.
Honig votes yes.
Representative Morin-Bello.
Yes.
Representative Osborne.
Yes.
Senator Sampson.
Sampson is no.
Representative Mastro Francesco.
No.
Representative Bronco. No. Representative Carpino. No. Representative Fonsello. Representative Gauthier.
Yes.
Representative Haddad.
Yes.
Representative Hoxa.
No.
Representative Johnson. Representative Menapace.
Yes.
Representative Rosario. Representative Santiago.
Yes.
Representative Shannon.
Shannon votes yes.
Senator Winfield.
Thank you, Mr. Clerk. And votes will be held open until at least the end of the meeting. And we will set a time if necessary later thereafter.